Hello guys, welcome back to another topic. So friends, today in this video I will share with you about the concept, one of the concept of Hindu Marriage Act, that is restitution of conjugal rights. Because whenever any dispute arises between the parties regarding a marriage, so we will see about the divorce, because we have not other alternate option, because we are not getting any advice from anyone, but we directly make the disputes, file we complaints. But there are also another matrimonial reliefs or grounds which, if you opted, definitely you will get rid out of from the marriage problems. So this is one of the sub aspect which we will see with the help of examples and with the help of case laws, because general meaning is a little bit confusing for you. But if we see about the provisions, what the provision says of Hindu Marriage Act on it. So basically section 9 of the Hindu Marriage Act deals with the restitution of conjugal rights. So what the provision says, according to section 9 of the Hindu Marriage Act, where either the husband or the wife, without any reasonable excuse, withdrawn from the society of the other, the agreed party may apply by a petition to the district court for restitution of conjugal rights, and the court, on being satisfied the truth of the statements made in such petitions and there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. So friends, general meaning is, if any husband or wife has neglected and left her matrimonial home and was not residing with husband or wife, as the case may be, the husband or wife may file a petition in the district court under section 9 of the Hindu Marriage Act by declaring that the husband or wife has left the matrimonial home without any rhyme or reason whatsoever, and the court will issue summon against him, calling upon him or her in court as to explain as to why you are not residing with her spouse, and he will pass a decree on it. If you are not wish to reside with his or her spouse, then please explain the reason for it, and if you are not followed that decree also, then it itself a ground for divorce. So why the amendment is required in it? By incorporating the section 9 of Hindu Marriage Act. So by the Marriage Laws Amendment Act 1976, section 9 subsection 2 has been omitted, and an explanation has been added to it, which provides that where a question arises whether there has been a reasonable excuse for withdrawal from the society, the burden of proving reasonable cause shall be on the person who has withdrawn from the society. That means if wife has left the society without any reason, then burden of proof will be on her to prove as to why she is not residing with her husband and or his family. So under section 9, the court may grant a decree for restitution of conjugal rights in the cases when either of the party has without reasonable excuse withdrawn from the society of the other. Second, the court is satisfied of the truth of the statements made by the petitioner in the petition for restitution of conjugal rights. And the third is, there is no legal ground as to why the application should not be granted. In the case of Shanti Devi versus Ramesh Chandra, the court held that in a petition or application for restitution of conjugal rights, the court must give a serious consideration to the evidence of the wife and her parents and cannot refuse to do so on the ground of their being interested witnesses. And in another case, Shanti Devi versus Balveer Singh, in this case, the petition of restitution of conjugal rights against the wife filed on the ground that the behavior of the husband has been cruel, torture towards her. So moreover, the husband was having some love affairs with a girl. The court in this case held it to be a reasonable excuse to her to live apart from her husband. Marital obligation also provided in this regard. In this, with one of the relevant case law, in the case of Saroj Jain versus Saroj Rani versus Sudarshan Kumar, in this case, if a consent decree for restitution of conjugal rights under section 9 of the Act is passed, it will not be declared as a nullity. If it is not challenged in an appeal or by way of other remedy available in law and becomes final, then it cannot be ignored and can from the basis of diverse proceeding under section 13(1)(a) of the Act be filed. In the case of Baldev Raj versus Bimla Sharma, in a petition for restitution of conjugal rights, alternate relief of divorce cannot be claimed. These prayers are mutually destructive of each other and therefore cannot be made together. That means to say, if you have filed a petition under section restitution of conjugal right under section 9, and on the other hand you have also take or file the divorce proceedings, so that these two proceedings cannot be made each other in a very similar court together. So these are the basically short concept on the subject of restitution of conjugal rights. If you need a format on it, please told us so that we will give you the very important informative video with the help of notes and with the help of the what are the format, how it is prepared, how it is filed in district courts. We will definitely help for you. If you have any queries regarding this video, please mention it so that we will respond to your queries or any comments. Thanks for watching this video.